The topic given to me today is, are ethics still relevant in today's medical practice? And I have been given the ethical responsibility of speaking against the motion. It's a difficult job because what is universally accepted, I have to be speaking against. I will take up certain points which I have seen raised. Dr. Tiwari has compared doctors to fathers of churches, but sir, fathers of churches do not get beaten up routinely as doctors do. Your other issue was, if doctors are not ethical, they will not be respected in society. Well, sir, doctors are no longer respected in society today. So is there any point in remaining fixed to our ethics? And number three is something which I feel the previous speakers are a bit confused on. That is, there is a difference between being ethical and being greedy or trying to earn too much, because ethics is something which is universally applicable. It is applicable to a resident doctor working in a government medical institution. It is also applicable to a corporate hospital. And the resident who's working in a medical college emergency has no financial reasons to be unethical. So the point is, they are the issues of who should be attended first. These are the issues which relate to professional ethics, and the earning part and the ethical part need to be separated. Then I am not so sure this is a correct message to give, that doctors who do not wish to toe the line which is given by the government in the ethical regulations either of 2002 or of the NMC RMP regulations bill of 2022, they should be leaving the profession. I'm sorry to say, we need change. We need change in the guidelines. We need change in the scenario. Doctors have been ethical, are ethical, will remain ethical, but the difference in what is actually ethics has to be understood very, very clearly. And if I can be assured, Dr. Verma, that I will not be sued, I will not be beaten up, if only I remain within my ethics. I mean, this would be heaven. This is a fairy tale, because under Consumer Protection Act, the judgments which have been given, 99.9% have nothing to do with the ethics of the doctors. They are based on things which are totally against. In fact, the whole point I'm going to raise in my talk or my arguments is this. So the first question is, we are talking of professional ethics. What ultimately are professional ethics? They are standards which are set by professional organizations. Please understand the word professional organizations, for behavior and values of people working within a specific field. So they have to be made by professional organizations in medical sense of doctors. Number two, I would say my definition of ethics is that it is a way of life and the way we conduct ourselves, which we imbibe during our professional training by observing and working with our teachers. Ethics is always self-imposed and related more to morality than law, which is imposed by outside forces. What the previous speakers are confusing is law which is imposed through regulations passed by NMC or by the Ministry of Health and Family Welfare by way of notifications or as a law by the Parliament. What ethics is, it is self-regulation. By definition, it is self-regulation and not something which is imposed by way of law. The Hippocratic Oath, yes, this was the first document on ethics, but is Hippocratic Oath the only document on ethics? We have Manusmriti, Kautilya's Arthashastra, so many documents on ethics in politics. Does that create any negative impact on the ethics of, on the image, the ethical image of politicians? Then Medical ethics, as has been mentioned by a previous speaker, are constantly changing. It is fluid. If you go through the history, from Hippocratic Oath in 5th century BC, there was Nuremberg Code in 1948, Declaration of Geneva in 1948, Universal Declaration of Human Rights 1948, Helsinki Declaration 1964, and now the NMC draft, NMC Registered Medical Professional Conduct Regulations 2002, which recently came into public domain. Believe it, it is 104 pages. Where did it start from? It started from Hippocratic Oath, which contained basically 5 things. Already Dr. Tiwari has elucidated to those. You have to do good. You should not do any harm. You should respect your teachers. Do not discriminate among patients. And prohibition against abortion, euthanasia, and sex with patients. These were the principles which were to be adhered to as part of medical ethics. The principle of patient autonomy and social justice, these were not part of medical ethics earlier. These are things which have been introduced by law now. And these are things which are causing the maximum heartburn. What is it that makes society consider doctors unethical in India? Is it that they do not try to benefit their patients? We always try to benefit our patients. Is it because they do harm to their patients? No, we never try to do any harm to the patient. Is it because they do not respect their teachers? Is it because they have sex with their patients? Is it because they conduct abortions? It is already legal in India. Is it because they conduct euthanasia? Law is confused on this issue. The reason why doctors are considered unethical in India is one and only one, that doctors have been victims of propaganda that they care only for money and fleece their patients. Unfortunately, among us, we have not been able to wipe our minds clear of this propaganda. If all doctors were so greedy and so much in search of money, I fail to understand why no doctor reaches the higher echelons of the people who pay the maximum income tax. I mean, they are okay in the upper middle income group. But are they the high earners of society? They are not. Then my second question is, you talk of professional ethics, but please define what is profession. The fundamental characteristics of a profession are: 1, it has to have great responsibility. Number 2, it should have accountability, and accountability means self-regulation. I'm again repeating the word self-regulation. Based on specialized theoretical knowledge, institutional preparation, autonomy. By autonomy, here under National Medical Commission Act, it is going to be rebutted that National Medical Commission represents doctors. But I'm going to show why it does not represent doctors. Because under NMC Act, the central government is the supreme authority for all matters. We are supposed to have clients rather than customers. We cannot, as doctors, we cannot choose our clients. We cannot choose our clients. So this creates a problem. There is a direct working relationship with the patients. Ethical constraints are there in a profession. Merit-based and morality is part of the profession. These are the characteristic things which define a profession. Now, Consumer Protection Act defined us, the healthcare, as trade. Patients are now consumers, they are no longer clients. National Medical Commission Act, there is no self-regulation, hence it is not a profession. I will prove why there is no self-regulation under National Medical Commission Act. Multiple judicial, quasi-judicial fora, no doctor to hold doctors accountable. Again, self-regulation means it has to be regulated by the regulatory body elected by the professionals themselves. Now, supposing in 1947, the Britishers had said, fine, we are going to leave India. You want Swaraj. I am going to nominate 500 Indians to rule this country. Would it still have been accepted as Swaraj? National Medical Commission, you have nominations. There is no election from the representative body into the regulatory body. the regulatory body should have been representative and elected by professionals. When you go to the preamble of the National Medical Commission bill, it states very clearly that principle of the regulated electing the regulator is flawed and creates a conflict of interest. Therefore, MCI should be discarded. It is a very bold, very provocative statement, which unfortunately, as doctors, as a group, we did not object to. We are in a democracy. And the people who are governed are the ones who elect those who are going to govern them. This is the principle of democracy. And here you are saying educated professionals cannot be depended on to elect regulators from within themselves, as there will be a conflict of interest. As if alcohol bottles and cash is going to flow in the elections, and this is what is going to happen. No, the control of the regulatory body was needed by the central government, and this was done through the National Medical Commission Act. In India, look at the following institutions which were set up under law for self-regulation of professionals with elected members: Bar Council of India, Institute of Chartered Accountants, Institute of Cost and Works Accountants, Institute of Company Secretaries, Council of Architecture, Press Council of India. Try and get this to be a nominated body. If we wanted a nominated body, what was the harm in National Medical Commission not being there and doctors being regulated by Ministry of Health and Family Welfare by creating a separate department? This is not self-regulation. And if this is not self-regulation, we are not professionals. If we are not professionals, what are we talking about professional ethics? Today's Indian doctor has to deal with increased government regulation, increasing cost of medical term technology, third-party payment system, aggression and violence, unsympathetic law and order machinery, half-baked medical knowledge, myths and misconceptions, and a demand from patient autonomy and documentation, but in a population which is largely illiterate. You can tell the patient all the 100 complications of doing an ERCP. But if there is a pancreatitis after ERCP, the only thing which the patient is going to tell is, we did not understand what you said. We gave you total power to do whatever you want, and now our patient is dead. So our violence and our filing cases against you in 8 or 9 different fora is justified. Today's Indian doctor, he's a businessman, he's an entrepreneur, he's an employer, he's a counselor, he's a manager, he's a taxpayer, and he has to deal with his responsibilities towards his patients, family members, employees, bankers, nation, society. Why professional ethics today is a book of 104 pages rather than the 5 principles it started from? You have changed the character of professional ethics and made it into a law. And that law is interfering with my actual ethics, which were taught to me by my professors when I observed and when I took my training. What is the basic reason? The basic reason is government, Supreme Court have decided that health is now a fundamental right. This is what the Supreme Court has said. Multiple judgments. I can quote at least 7 or 8 judgments where this has been decided that under Article 21 of Indian Constitution, the right to health is now a fundamental right. But if you go to the Paschim Bengal Khet Mazdoor Samiti versus State of Bengal judgment, it said very clearly, it cannot be ignored that the constitutional obligation of the state to provide adequate medical services to the people. Indian state has, however, pushed this fundamental duty onto private doctors under the garb of ethics. Please understand each word of what I am saying very, very clearly. Under the garb of ethics, the fundamental duty which was to be performed by the government has been passed on to the profession as a whole. And it affects the private sector much more than the government sector, which is anyway performing the function for the government. And also, I have to act as per law. not as dictated by my own ethics in India. If I give you examples, if I don't follow my ethics, it is like I'm not following my mother's advice. But if I'm not following law, it is as if I'm not following what my wife has told me to do. There is a difference between the two. When there is conflict of medical ethics and law, it is law which always wins. I will give you an example. In an emergency department in PGI, there are more than 50 patients at one time who are being bagged by through endotracheal tube by relatives because there is no ventilator available. Now the senior resident gets one ventilator from the ICU, which becomes available. And it is his decision out of these 50 which patient he is to give this ventilator to. Law, according to law, a person who's having a high income, the doctor, if he is sued, the person who has high income to start with will be awarded much higher compensation than a poor patient. I am told not to discriminate on the basis of social standing. Simultaneously, I am told if I do not provide a ventilator to the mother of the judge from High Court, one, I will have a CBI inquiry against me. Totally acceptable. This has happened in PGI. If there is a Supreme Court judge who's being treated and there is some allegation of negligence, the complaint will go to the Prime Minister and the Prime Minister will initiate the inquiry. And if a high compensation, if a person is high net worth, otherwise earning maybe let's say 2 lakhs or 5 lakhs a month, then under those circumstances, compensation which will be awarded for not giving him ventilator will be 50 crores or so. So my point is, law is forcing me to discriminate between patients on the basis of their socio-economic status. Because when you are awarding compensation, you are awarding according to the earning capacity of the patient, not according to what negligence I have done. This is a flaw in the law and it conflicts with my medical ethics. Then, if a doctor has to accede to a relative's request, this happens daily in all ICUs in the country. The patient's relatives initially, doctors do everything you can. Once we have put the patient on ventilator, through second day, third day, fourth day, they are no longer able to afford the cost. The doctor understands the patient's relatives cannot afford the cost. They beg you to switch off the ventilator or somehow let the patient die, but law does not permit. If I follow the law to switch off the ventilator, it will take me at least 2 months to get permissions to switch off the ventilator. This is a conflict between medical ethics and law. I am with the patient's relative. I don't want the patient's relative to spend money. But the law does not permit me to switch off the ventilator based on a relative's request. Then for a patient who has cardiac arrest, and I am asked, despite knowing very well the patient will not survive, or despite knowing very well we have already revived the patient 10 times earlier in the past, and there is no chance of this patient surviving, but law does not permit me to decide that we will not resuscitate. Similarly, how many doctors today would stop at an accident site to assist a patient? Why? I will tell you. We had a professor in PGI. There was an accident while she was coming from her home to PGI. There was an accident on the roadside. She stopped the rickshaw puller. She put in her car and the accident was not with her. She was a passerby. She brought the patient to PGI emergency. She was made an accused and she had to fight a case for 10, 12 years to get off from the allegations. Similarly, doctor using surrogate mother to deliver child of Karan Johar, law permitted it that time. But it was, if you ask me today, it is against my ethics. For a doctor to desire that the patient he is resuscitating dies, but does not go into a vegetative state. Because today, as the law stands, if a patient goes into a vegetative state, the compensation as it is calculated will be much, much more than if the patient dies there and then. This is against what I was taught when I was in medical colleges. When a patient goes into cardiac arrest, I am told to resuscitate irrespective of what the outcome is going to be. The thought never came into our mind that this patient may have brain damage. We used to keep resuscitating for up to half an hour at a time, and sometimes these patients did come back. I am one of those who was resuscitated and I came back, and it is nearly 17 years since I was resuscitated. But law forces doctors into a corner. Then for a doctor to close the abdomen during appendectomy, despite finding an inflamed Meckel's diverticulum, knowing that another surgery will have to be done in near future. This is Samira Kohli versus Dr. Prabhavan Chanda judgment. If I have not taken consent for a particular procedure and on be doing a surgery, I find another surgery has to be done, I have to stop the surgery, allow the patient to come out of anesthesia, take consent for the second surgery on a different date, and go ahead and do. Even if you think it is in the patient's interest, you cannot do what you think is ethically correct. Routinely, we used to be taught that in case we were operating for a gallbladder or we used to be operating on the intestines, appendix used to be removed routinely. Today, law prohibits it. This is again a situation where there is conflict of ethics and law. And of course, law will win. So routine test of this case of Sanjay Mutha versus Dr. Jayashri, listen to what the High Court has to say in this. Had Shrimati Rupa Mutha died during the procedure, it would not have given so much trauma to husband and daughter, hence imprisonment for doctors. The doctors had done a test for patency of fallopian tube and gas embolization happened, cardiac arrest occurred, they resuscitated, patient went into vegetative state. The court says it would have been better if the patient had died. This, I find, was totally against what I have been taught and what I consider to be my medical ethics. For a doctor to know he can save life of an individual by doing a procedure, but he does not do it. Why? Because one, it is a high-risk procedure and it is being done in an establishment which does not have an ICU. And he is afraid what the court's view will be later in case of a negative outcome. But when we do this, when I know I am competent to operate, when I know I can save the person's life, when I know very well if I refer this patient, the patient will die on the way. But I still do not do the procedure because I am afraid that tomorrow the court will ask me, you did not have an ICU, why did you operate this high-risk patient? Similarly, a surgeon who does not operate without an anesthetist in a patient with fetal distress, knowing the fetus will be dead by the time the patient is shifted to higher center. Again, these are situations which are arising, which are in conflict with our medical ethics, where the law is intervening. Patient dying, driver who is also being paid is a donor who is available, but doctors cannot do a renal transplant. Do you know how many people die without renal transplant every year? More than 1,25,000 people die every year for want of renal transplant. There are people who are willing to donate the kidney, but paid kidney donation is illegal. So even though you know that this driver has been working with the fellow for the past 20 years, there is a good relationship between them, but the owner has offered the driver some money so that he can also look after his family. And this makes it against law, so we cannot do it. But supposing if people were allowed to sell their kidney, one, there would be no illegal trade, no exploitation, no middlemen. Checks and balances could be brought into place to safeguard interests of donor. Countless lives on both sides would be saved, potential recipient and potential donors, and no doctors would be arrested so that newspapers can sell based on sensational headlines. There are countries where sale is regulated by the National body which looks after the transplantation process. And it is time to start thinking out of the box, and being within a very rigid straitjacket of the law is difficult, because I personally feel if a person is dying and I have the competence to help the person and I'm not helping the person because of the law of the land, there is something wrong somewhere. Medical termination of pregnancy is illegal in some countries. But with 23-week-old fetus surviving with proper care, is it ethical to permit MTPs up to 24 weeks, as has been done in the new MTP Act? Again, a conflict between law and my ethics. Forcing anesthetists to take up cases not fit for surgery, even in government institutions, is that ethical? The God complex surgeons throwing tantrums in operation theaters against anesthetists, residents, and nurses, is that ethical? I have another question to ask. Being awake for 24 hours is equal to having a blood alcohol content of 0.10%. And if doctors working under the influence of alcohol is unethical, then so is forcing them to work in sleep-deprived state. Then how are we so proud that we used to be working for 72 hours non-stop in our residency days, and doctors today are weak and they get tired after working only for 12 hours? This is unethical expectation on behalf of us seniors from our junior doctors. The demands of globalization, corporatization in healthcare leave no scope for professional ethics. Healthcare is significantly affected by globalization. Despite its public good and non-commercial nature, new business opportunities have been identified within healthcare environment, and business ventures and collaborations have stepped in. Globalization is mainly due to the decline in public sector expenditure and the liberalization of related sectors such as insurance and telecommunications, increased mobility of consumers and health service providers, and technological advances. The differences in cost, availability, and quality of healthcare, the emergence of investment opportunities in healthcare sector with liberalization of investment regulations, and general increase in demand for health services arising out of income levels and aging population. Healthcare now has shifted. It has been identified as a sector where money can be made. And this has been identified by corporate giants. It has been identified by businessmen. And healthcare today has shifted from the hands of medical professional ownership to businessmen, hence no relevance of ethics of professionals in business enterprises. Medical education for sale. Till 2009, only non-profit trusts and societies could run medical colleges. In 2010, firms under Companies Act were permitted to run medical colleges. Then August 2016, companies run medical colleges for profit. This was allowed. In January 2017, even existing non-profit trusts and societies were allowed to convert into profit-making ventures. And new education policy has now done away with all fee regulation for all courses. So in summary, healthcare is no longer a profession in India. It may be a provocative statement. I'm going to stand by it and I'm going to argue it. This has been done under Consumer Protection Act as well as National Medical Commission Act. Globalization and corporatization has changed the character of healthcare. Cost of newer medical technology is high, and investment and return are the new buzzwords instead of care and compassion. Over-regulation has eliminated small and medium healthcare establishments from healthcare scenario. These were the mom and pop stores or mom and pop nursing homes which were dotting the country, let's say around 2 to 3 decades ago. And these are all now closing in favor of larger corporate setups. Interference of law in matters which were essentially medical leaves little scope for professional ethics. I've given you umpteen examples. I mean, it's up to you to judge whether those examples are correct or not. Doctors are mere tools for the healthcare industry. We no longer own healthcare industry, and professional ethics are used to keep a check on the doctors, to make them toe the government line, to make them toe the businessman's line. Hence, in my view, ethics today has no role in healthcare in India. Thank you so very much.